for each branch to act, exercise separation of powers. Let me give you final examples here on how this was done in the history of the United States. You take Thomas Jefferson. He's President of the United States. His Secretary of State is James Madison. That's two guys who have a clue about constitutional intent, I would argue. I mean, they know something about it. They had a decision of the Supreme Court called Marbury versus Madison, where the Supreme Court said, Executive Department, you need to deliver these commissions to these 17 judges, district judges in Washington, D.C., these justices of the peace. And so we, the Supreme Court, are telling you that this is what's constitutional, and you guys go ahead and do it. Now, when Jefferson and Madison got that order from the Supreme Court that we ruled, and here's what's constitutional, number one, they both looked at it and said, they got to be crazy, and they ignored the order. Then what they said about it is interesting. Jefferson called it a perversion of law that the Supreme Court would attempt to tell the other two branches what to do. He said that's a perversion of law. And then he called it gratuitous interference. How dare they cross the separation of powers and try to tell another branch what to do? It just sent him through the roof. The other thing that happened was called the Alien and Sedition Acts. Alien and Sedition Acts, Congress said, we're going to pass a law so that if you criticize the President of the United States, you're going to face criminal proceedings and you'll have jail time. And that was done because they didn't like the criticism that was coming to the President, obviously. And so 25 people were prosecuted and went through, and the courts looked at the law and said, yep, Congress passed it and that's fine, and they can do this, and so we're going to convict these people. And 25 people had big fines, went to jail. As soon as Jefferson found that, he voided all the laws and released everybody out of the prisons. He said, this is an unconstitutional law. I don't have to have the courts to tell me that, and I don't have to have the Congress to tell me that. It's unconstitutional to tell people they can't criticize the President of the United States. Now, everybody today agrees with Jefferson's assessment, but you know why those people got out? It was because he felt the separation of powers allowed him to stand up for the Constitution even if the other two branches got it wrong. That's part of the checks and balances, is standing up and confronting the other branches. You also have President Andrew Jackson. Andrew Jackson had a number of decisions where the Supreme Court came at him, including decisions like Worcester v. Georgia and Osborne versus the United States. And when the court came down and said, President, here's what you have to do, and here's what's constitutional in regard to the national election, etc., I love his response. Jackson looked at the decision of the U.S. Supreme Court and he said, well, the Chief Justice has made his decision, let's see if he can enforce it. Real simple, you know? That's his opinion. I want to see him come over here and make me do it. There's no way he's going to make me do this. And Jackson released a document that is still, it's part of a presidential document, went to Congress, he explained why he's ignoring the court. This is what he said. He says, each public officer who takes an oath to support the Constitution swears that he will support it as he understands it and not as it's understood by others. In other words, I took an oath as President to uphold the Constitution. I didn't take an oath as President to uphold the opinion of the U.S. Supreme Court. I'm going back to the Constitution. He says the opinion of the judges has no more authority over the Congress than the opinion of Congress has over the judges, and on that point, the President's independent of both. He says the authority of the Supreme Court must not therefore be permitted to control the Congress or the executive. Jackson was a great example of checks and balances and how it worked, and that's how they kept judicial activism in control. One other example I'll give you is President Abraham Lincoln. Before President Lincoln got there, the Dred Scott decision come down. You remember the Dred Scott decision? That's where the court gave us that famous line that says, no black man has any right which a white man is bound to respect. And the Supreme Court said, by the way, since blacks are not people, but they are property, you cannot free them, you cannot forbid slavery in any territory, you cannot do civil rights because this is property. These are not people we're talking about here. Well, in the debates that came after that, presidential and the senatorial debates,